Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola law firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Law You Should Know, and tonight we're going to talk about, this afternoon we're going to talk about with Eileen O'Toole, and she's a landlord-tenant attorney, mainly concentrating in the rights of tenants. And we're going to talk about many of the important changes that were made, many of them which give tenants more rights under the recent changes made by the New York State Legislature in 2019. There are several programs about them, and if you tune in next week or listen to the podcast from next week's show, you'll learn about additional rights of tenants and responsibilities of landlords. Eileen, welcome back to Law You Should Know.
Thanks, Ken.
So, under the new rules, the changes that passed by Albany, which affect tenants primarily in New York City, but in the parts of the suburbs as well, some of the terms were changed, and tenants were given very important additional rights. So, tell us about some of the rights they now have concerning rent and security deposits.
Okay, well, if we're talking about rent and security deposits, there were changes both to the real property actions and proceedings law, which is procedural laws having to do with housing court proceedings, and then there were changes also to the security deposit law. These are state laws. For one thing, if a landlord is suing a residential tenant for non-payment of rent, and that's an eviction proceeding based on non-payment of rent, the term rent is now limited to strictly your rent, not things that are usually called additional rent, things like garage payments or health club charges or utility charges. A landlord can't seek those in a housing court proceeding. They have to bring a separate proceeding in civil court, just for the money. As far as security deposits go, if you'd like me to talk a little bit about security deposits, generally, if you're a rent-stabilized tenant, a rent-stabilized tenant generally only pays 1 month security deposit. That's the rent stabilization law. There's not usually much questions coming up about that. But if you're an unregulated tenant, before June of 2019, there was no restriction on how much security deposit you could ask for, or you could also ask for prepayment of rent, which sometimes in some instances landlords would do. But now the general obligations law of New York State specifically limits the amount you can collect to 1 month's rent. That's either as the security deposit or as prepayment of rent.
So this is even for luxury rentals. The most the landlord can take in advance is 1 month rent as security?
Yes, that's correct. It's specifically for those type of tenancies. The law states that, other tenancies, mostly the rent-stabilized tenancies or rent-controlled tenancies, or sometimes you have certain types of housing that are under some kind of government regulation. Those generally are limited to 1 month security deposit already. But now, whether your rent is $500 a month or $3,000 a month, the landlord can only collect 1 month's rent. And on top of that, in some instances, if say the landlord is a university and is renting to students who are from out of state or from other countries, or if a tenant had a questionable credit history, a landlord might agree to rent the apartment if, a year's rent was paid in advance. Under the change in the law, you can't do that anymore. The law doesn't allow the landlord to collect more than a month's rent, to collect prepayment of rent at a time. So it creates a restriction on the landlord, and it may actually prevent rentals to, certain types of tenants who previously, would pay up front. This could also affect people who have, people may own a home that they rent out during the summer, for summer rentals. And I think traditionally what people would do is collect the season's rent all up front. And now, under the changed law, you can't do that.
So this would even cover renting a house in the Hamptons?
Yes, that's correct.
Okay. So there's important news out there. I also want to remind attorneys who are listening to the program that you can earn CLE credit for this show through the Nassau Academy of Law. Be sure to record the code that will be given at the end of the program. Eileen, what are some other changes involving evicting someone or one person, let's say, residing in an apartment occupied by several people?
Okay. Well, generally, there's two types. If you are trying to evict either a tenant or someone who is occupying an apartment, for more than 30 days, there's no such thing in New York. There hasn't been generally. You can't use self-help eviction. You have to go to housing court. You have to bring an eviction proceeding against people. And if sometimes if it's not the tenant, if there are other people in the apartment, you may not know their names and you may call them John Doe or Jane Doe starting out. The landlord should try to know who's in there. The law, the RPAPL, the procedural law for housing court actions, now says that it specifies that the landlord can evict a tenant or a lawful occupant without starting an eviction proceeding. So this actually affects not just conventional landlords, but you do have situations where you may be the tenant of an apartment and you may have a family member who moves in with you, or you may actually own a house or an apartment and have a family member who moves in with you, or you may have a girlfriend or a boyfriend who moves in with you. And the relationship sours and you're the tenant or the owner of the unit and you want the other person to move out. You can't just lock them out or force them out. You have to start an eviction proceeding against them if they, if it's not something you can resolve between yourselves.
And that's not even the landlord's job. You would have to start your own eviction proceeding.
That's right. If you're a tenant and you have someone who has moved into your apartment with you that initially you allowed in, and there comes a point where you want them out, you can't just kick them out. You actually technically are supposed to start an eviction proceeding against them.
If you haven't received rent from them, when do they convert from a non-transient occupant to, let's say, a lawful occupant?
It's generally 30 days. The law says a non-transient lawful occupant is someone who's in there at least 30 days.
So even if you let a friend stay with you, if you took a homeless person in, if they're more than 30 days, they acquire rights.
That's right.
And this is whether or not they're paying you money.
That's right. To be a lawful occupant doesn't necessarily mean you're paying somebody rent. That's correct.
And to go back to the part you mentioned before about the notice, so the landlord has to name and serve everyone specifically?
Yes, they should. Sometimes there may not be, you may not realize there are other people, as the landlord, you may not realize there are other people living in a unit, or sometimes you may know that there are other people there and you suspect the tenant's not even there. But even if the tenant is not there, you have to name the tenant. And if you don't know the other people's names, you call them John Doe and Jane Doe in the initial court papers.
But if they're not there, if you just name the name tenant or record, those people are not being evicted.
That's correct. The way the law is written, if you don't name someone in a proceeding, you can't get say you win the case and get a judgment and a warrant to evict. It won't name anyone else. It'll just name the tenant. So you can have problems down the line if you don't have people named on an eviction warrant, if a court issues an eviction warrant, and then the marshal goes to the apartment to evict people.
And this is also important for everyone to remember. Just be careful who you let move in with you.
Right.
Because you cannot just throw them out, even if they're not paying you, and even if relationships have soured. So let's just move on. I just want to remind everyone you're listening to Law You Should Know here on WHPC 90.3, the voice of Nassau Community College. And also we're broadcasting over the internet at nccradio.org. And if you missed any portion of this program or want to tell anyone else about it, they can just find the podcast at nccradio.org. And we're talking with Eileen O'Toole, and she's an attorney who's an expert on landlord-tenant law. And we're talking about the new rights of tenants as of now, just recently granted by the legislature. Let's talk about the landlord serving rent demands and how that's changed.
Okay. There's two types of eviction proceedings you can have, and one of them that involves rent demands. There's one type that's based on non-payment of rent, and then there's another type based on all other kinds of lease violations. For non-payment of rent, I think you've discussed in a prior show that the first thing you have to do now, under the law amended in June of 2019, the first thing you have to do is send a letter to the tenant by certified mail saying, we have not received your rent. If the rent is in fact late. Most leases have a provision that may say the rent is due on the 1st of the month. It may say the rent is due by the 5th of the month. And if you don't receive payment by that date, the first thing you have to do is now send this certified letter saying we haven't received your rent. The next thing you have to do, which you've always had to do, is give the tenant a rent demand for the amount of unpaid rent. Now, in the past, a rent demand could be oral or it could be written. And, maybe some small landlords or people who lived in the building would do oral rent demands. The law has been changed now. You cannot make an verbal rent demand anymore. You have to send a rent demand that outlines what is owed and says, if you don't pay it, we're going to bring a court action against you. The rent demand was traditionally, under the law, a 3-day demand. Unless the lease said you had to provide more time, you only had to give 3 days notice of the rent demand before you'd start a court case. Now you have to give 14 days, and that means, serving the rent demand notice at least 14 days before you take any further action. And then if the tenant does not pay within the 14 days, you file what's called a notice of petition in housing court that's also served on the tenant. Generally, people use process servers to do that. And you file a copy in court and with the court clerk. And if the tenant doesn't answer the non-payment petition, the landlord then can ask the court to issue a default judgment in the landlord's favor and issue an eviction warrant.
So just one aside to tenants, you should always respond, even if you do it on your own, even if it's not perfect. If you serve with some kind of legal notice or notice from the court, you must respond.
Yeah, and the notice that you receive will tell you how much time you have to respond. It'll tell you it should tell you where the courthouse is and where you have to go. And if it's a non-payment petition, you go to the court clerk's office and they'll help you file an answer if you don't know how to file an answer. And then they will send notices both to the landlord and the tenant telling them when there may be a court date.
So let's talk about some other changes in the Real Property Actions and Procedures Law or proceedings, and this is in 7731. There's a new subsection. Tell us about that.
Okay, that section says that if you start a non-payment proceeding against the tenant, and before there's a decision made by the court, the tenant is giving you money to pay the rent, that the landlord has to accept it. Now, this is an example of something that a lot of these changes to the law have done. They've put things into the law that actually were already the practice. I believe that up until this point in a non-payment proceeding, if you paid the rent before there was a court decision made, there wouldn't be any ruling against you as the tenant, except that you might have to pay attorney's fees, because the landlord has to take you to court. But now it says that in the law that that the landlord has to accept the rent. The law doesn't say who has to pay that rent. And the way the law is written, whether if someone else who lives in the apartment or someone who's trying to pay the rent on behalf of the tenant offers you the money while you're in court, whether you have to accept it.
And so this was common practice or the rules of judges or case decisions before, but now it's been incorporated in the law. That's
right. That's right. And the other thing, when you start the non-payment case, you also have to, the non-payment petition. I mentioned before that, in non-payment petitions, there'll be instructions in the court papers saying, go down to the clerk's office to file your answer and also mail a copy to the landlord. And you used to have 5 days to do that, and now the law gives you 10 days to do that.
So you have a little more time to figure out what to do, and perhaps you go to some organization that helps tenants, or just consult with an attorney, especially if you have a lot of money at stake, and protect yourself as best you can. Tell us about the holdover petition. First of all, tell us what that means and changes in the procedures.
Okay, a holdover. As I said before, there's two types of eviction proceedings. We've talked about the non-payment proceeding. A holdover proceeding is when you are getting a notice. First, you get a notice before the case is started saying, we're terminating your tenancy because you're doing one of the following. It could be you made unauthorized alterations in the apartment. It could be because you chronically pay your rent late or don't pay your rent, which is a little different than just a standard non-payment case. It could be because you're creating a nuisance. It could be because you were supposed to renew your lease and you refused to renew your lease. So in those cases, the landlord sometimes has to send a notice to cure. If you don't cure, you get a notice saying your lease is terminated. And if you don't, then once you get the notice saying your lease is terminated, then after the termination date, and if the tenant is still there, the landlord starts an eviction proceeding called a holdover proceeding, and that notice is served on the tenant by a process server. Usually, it used to say, in 5 to 12 days from now, whatever date was set, you have to come to court. Now, that one's also been extended. It's now 10 to 17 days. So, as with many of the other changes to the law, there are built-in advantages for the tenants. There are a lot of things just giving them more time, or giving them more time to respond to things, giving them more time to, make deposits of rent into court while cases are pending, giving them more defenses to things too.
And if you cure the condition that was causing the holdover proceeding, will that be a grounds to dismiss it? If you get rid of the pet or the noise or the mess or the alteration?
While a case is pending, or usually say there is a decision for the landlord, in most cases, except I'd say for nuisance cases, the court will give you, and the law says now the court will give you some time to cure the condition. You will be given time to cure the condition, even if it's at the end of the case and you hadn't done it already, maybe because you were disputing whether you had to cure the condition. Like with pet cases, if someone's holding out and arguing they should be allowed to keep their pet because the landlord waived the right to bring the pet case, or that you're saying that the animal is a service animal, and say it's the tenant, you lose. And the court says, no, landlord wins, you have to get rid of your pet, but we're going to give you still a little more time to do that. You can do that. Where you won't get more time is, say the case is based on nuisance. The case is brought because the allegation is the tenant's conduct is objectionable. The tenant is someone who harasses other tenants, has maybe assaulted somebody, makes a lot of noise, maybe has criminal activity going on in the apartment. So that's something. If it is found that it's a nuisance, it's something that by definition can't be cured. So you're not going to be given the opportunity to try to cure something like that.
Okay. I just remind our listeners, we're talking about new rights of tenants. If you're an attorney and listening to the show, you can use it for earning CLE credit through the Nassau Academy of Law. And just be sure to record the code at the end of the program. And if you missed any part of the program or you want to tell someone else about it, it's available at nccradio.org. And you're listening to 90.3 WHPC, the voice of Nassau Community College. So, Eileen, we just have a few more minutes in this particular program about new rights of tenants. So let's talk about other proceedings once there's a possible eviction or ordering eviction or carrying out the eviction. Significant things that's important for tenants to know.
Okay. One of the things that has happened now, there's been some extension also. I think, talking about time for tenants being extended in these proceedings. There's now some wrinkles added when a court issues an eviction warrant. In an eviction case, what happens at the end of the case is if the court is going to rule for the landlord gets a judgment in its favor. The judgment will say landlord wins and tenant owes this much rent to the landlord, or landlord wins and yes, tenant has created a nuisance and tenant has to move out, and therefore the court gives the landlord a judgment and issues an eviction warrant. So an eviction warrant gets issued, but when someone is actually evicted, that's when the eviction warrant is executed on. So now when the court issues an order and is giving an eviction warrant, it has to state the earliest date when the execution of the warrant may occur. That's something new. And it must also make a statement that upon the showing of good cause, the court can issue a stay of the eviction. Sometimes when there's an eviction warrant issue, the tenant might come back and ask for additional time.
And this also gives you the tenant some time to move on their own or pack up these things and perhaps avoid the consequences of an actual eviction by the marshal?
Yes, that's true. That's true. And in addition, while the court issues an eviction warrant, when the marshal is then getting geared up to actually, go through with the eviction, the marshal has to send a notice saying you can be evicted, or you will be evicted on such and such a date. Now, the marshal's notice up until June had to give 72 hours notice that the eviction was going to be happening. Now the marshal's notice must give 14 days notice. And also, this was already in the law since a year or so ago. When you were talking about pets before, if a marshal comes to evict the tenant and no one's there, and the marshal finds there is a pet in the apartment and can't get a hold of the tenant, the marshal actually has to call, animal services to pick up the pet, so that you don't have an abandoned pet sitting in an apartment that somebody's been evicted from.
And this would include alligators as well?
Yeah. Yeah.
Okay, we just have about 2 or 3 minutes left in this portion of new rights of tenants. Any other changes you want to make, or any other points you'd like to emphasize of ideas you've discussed already?
What I will point out, there are actually new provisions concerning unlawful eviction. Unlawful eviction is evicting someone who, without going to court. Like we said, you're supposed to go to court to do that. So now it's been made a criminal offense. It's a Class A misdemeanor if you unlawfully evict someone. And civil penalties can also be enforced, $1,000 to $10,000 for an offense. And you can have additional daily penalties of $100 a day if you've unlawfully evicted a tenant and they're supposed to be restored to possession.
And this would also include for someone in the apartment locking out someone,
Yes,
like as you
right.
discussed in the beginning of the program.
That's right, in more family-type situations. That's correct.
Or it could be you're running a rooming operation and you're attempting to lock out someone. Whatever it is, there's no self-help.
That's right.
For attorneys who've been listening to the show on New Rights of Tenants, the code number for CLE through the Nassau Academy of Law is 3214, and you can contact the Nassau Academy of Law at 516-747-4070, and there may be an administrative fee. If you want to listen to any portion of this program again or other programs about this or other legal issues, just listen to the podcasts that are available at nccradio.org. Eileen, do you cover in your practice all the courts in New York City?
In theory, yes. My office is located in downtown Manhattan. My practice is primarily in Manhattan, but I also, have appeared in Queens and Kings County, less frequently in the Bronx. I think I've gone to Staten Island twice in my career, but there are, within New York City, there are housing courts in all of the boroughs. Yes, so I have been involved in landlord-tenant litigation throughout New York City.
And we have you on here because you're very experienced and a very good communicator concerning these issues. Keep in mind, if you Google some of these terms, you might be led to relevant information. And most public libraries will have copies of the statutes, and you can look up the laws for yourself and see if you can find any information that helps you. So I want to thank you for listening to Law You Should Know and our guest, Eileen O'Toole. You've been listening to New Rights of Tenants, and attorneys can use the code 3214 to earn CLE credit for this program. Please join us next week at this same time for Law You Should Know on 90.3 WHPC, also over the internet at nccradio.org, the voice of Nassau Community College.